Notorious serial killer and rapist Paul Bernardo will stay in a medium security prison. A review of the decision to transfer him there found the decision was sound and completed in compliance with legal and policy frameworks.
We want justice to be served. And in the case of this inmate, he was given the harshest sentence possible in our Canadian criminal justice system. I can assure you that we are doing our job by keeping him securely behind bars in a federal penitentiary, and have been for close to 30 years and counting.
Bernardo is arguably Canada's most notorious killer, and his transfer from maximum to medium security launched a firestorm of controversy over perceptions he would serve lighter time or one day end up in minimum security.
I want to be clear here that despite being a medium security inmate, he is still assessed as a high risk to the safety of the public, even after close to 30 years of incarceration. He also continues to hold a dangerous offender designation, which was imposed by the court. No inmate who is a high risk to the public can go to a minimum security institution.
According to the review, Bernardo has been recommended to be a medium security prisoner since 1999 under the security reclassification scale. But this was overridden for decades because of his high profile, his failure to integrate into the ward, and the security risk to him personally. The transfer came this time around because Bernardo better integrated into the prison population and because he's going to a facility that deals with high-profile and sex offender criminals. Now, in terms of notifying the victims' families of the transfer, Ann Kelly said corrections went above policy to notify victims, but additional steps could have been taken to provide more information.
CSC could have had more proactive and meaningful discussions with victims in a manner that still complied with the Privacy Act.
For more on this story, I'm joined by Andrew House. He is a former chief of staff for two Conservative ministers of public safety. Andrew, thanks for joining us.
Great to be here, David.
So the review documents that were released today and the press conference from Ann Kelly gave the most comprehensive explanation for how this happened. Well, what's your takeaway from this review in terms of how it answered some of the questions that were out there?
Well, let me start where Commissioner Kelly started, which is with the families. Those left behind after these horrific crimes, and I think she was right to start there. That's where most Canadians go when they think of this scenario. And I went back and read some of the coverage from that era and listened to some of these true crime podcasts, and it just brings you sharply back to what we're all debating here, which is the crimes that were committed, how they were dealt with by the courts in a really complex way, and then, of course, how punishment was administered, including how this transfer happened. And, of course, I come from a background where I was in a previous minister's office, and so this hits close to home for me. And a lot of what Commissioner Kelly said today brought me back and really resonated.
But in terms of the political controversies that have been out there, the explanation we got today is that this is a pretty long-term and deliberative process. And Bernardo was only moved when it became clear to them that he was not a threat to the prison population, and the prison population wouldn't necessarily be a threat to him, and he could be managed in medium security. They still say he's a clear high risk to the public and will likely never, ever get to minimum security. But in terms of the rationale behind the transfer, does it make sense now that they've shown their work?
So what's interesting here is the amount of time that elapsed from knowledge of this transfer to the point at which it occurred. The Prime Minister's office was aware, the minister was aware, minister's office rather was aware. That never happens in this department. You never get the luxury of time. And the rules as they are written were indeed followed. And the question on everyone's mind is, are the rules correct? For instance, the right as part of the Victim's Bill of Rights to know that a transfer is occurring is not in the Victim's Bill of Rights. I was relieved to see the minister issue direction today, but even that direction implied that the Correctional Service did something wrong. And I just don't see it. They did their job. Ann Kelly did her job. Officials at Public Safety Canada did theirs. And there was 3 months of lead time to change the Victim's Bill of Rights. If they wanted to do that, they would have most certainly had support from the Conservative opposition. and chiefly to change the correctional regs, which really give the criteria about when someone is tiered down in the language of CSC. So they applied the rules as written, and the real question is, why weren't those rules thoroughly examined in light of what was about to happen and potentially changed by regulation? That can be done. I've seen it done in 48 hours, and it could have been done here.
Right, but the review has concluded that the rules were followed, the communication protocol was followed, as unsatisfying as it is to the families, to be notified day of, and there is a recommendation to correct it going forward and a directive from the minister to correct it going forward. So in terms of where we are now, the fact that Bernardo will stay in medium security, where does this leave the political controversy, do you think? Because the deficiencies, they seem to have a corrective path for it.
They have a corrective path. I think what's so painful to watch here is a scenario in which the Correctional Service does its job. There's tons of lead time. The minister's staff are apparently aware, and they don't brief up. And it really left that minister very vulnerable. That's a process that will play out over the next couple of days and weeks as we look at a cabinet shuffle. Really, I think the victim, along with those who have suffered so badly, is public trust that the system is working. The minister appeared to deflect blame onto others when, in fact, I think Canadians really want a sense that, look, someone is in charge and someone knows what's going on. And when things get broken, as they invariably do in that portfolio, there is a minister who's going to stand there and say, that was my fault. I completely own this, and here's my plan to go forward. Right. The controversy roiled so badly because no one did that right at the beginning.
Right, but there's two things. Anne Kelly said today, the minister cannot overturn the decision. That's a translation. She said it in French. And in the statement that was released by her department, the final bullet point is, the minister does not have a role or authority in security classifications or the transfer of offenders. So I appreciate there was a breakdown in communications and briefing up in the minister's office. The minister has copped to that by now. But that would not have necessarily changed what happened here, right? In terms of this decision to transfer him, it was CSC's decision. It was corrections' decision.
So let's be clear about an important distinction that I think has really been lost in this debate. The minister has no role in a transfer decision about a specific offender, nor should any minister get to decide as a political actor who gets arrested, who gets prosecuted, or where an inmate, a specific inmate, resides within a system. But the minister is entirely entitled to issue directives about classes of offenders, and what would be far better, and I think more compliant, would be for the cabinet to issue regulations about classes of offenders. For instance, anyone designated a dangerous offender, as this inmate famously is, that could be taken into account in the regulations. So no, a minister doesn't direct that inmate gets moved up or down the tiering chain, but the cabinet could have had a role here very appropriately in an ordinal ranking of the factors that the service is to consider. That didn't happen despite the fact that there was time, and this I think is really the tragedy.
But you just said they shouldn't be involved in individual cases, but if given notice of a Paul Bernardo transfer, and in no way is this a defense of Paul Bernardo. But if once given notice of a Paul Bernardo transfer, if they then change the regulations in a way that specifically targets him, they're essentially doing that. They're essentially targeting an individual in the penal system by changing the regulations to stop the transfer. I mean, aren't you doing this through the back door in that plan, what you're not allowed to do legally through the front door?
These very difficult cases, very high-profile cases, illustrate deficiencies in the system, deficiencies of general application. I agree with you. It is not appropriate to change a law based on a single inmate. But Paul Bernardo is not the only dangerous offender in Canada. Right. There are many. There's a class of offender here and a class of victim that we are not appropriately handling in this country. And in the case of victims, that should be enshrined in the Victims' Bill of Rights. They have a right to know that someone's classification is changing. And on the inmate side, once you achieve a certain level and dictated not by a minister, but by a judge, and maybe that trigger factor is you're a dangerous offender, The cabinet could pass regulation that would deal with that class of offender. Paul Bernardo is only illustrative of that class. He's certainly not the only member.
But just as a final point, because I was listening to Ann Kelly today, and she said him moving from maximum security to medium security doesn't fundamentally change his prison experience because of where he is going. He's still behind the high walls with the armed patrols. He's just in a different population makeup where the inmates are less of a risk to each other and less of a risk to the staff, as opposed to a maximum security where 95% of them are in there because they can't regulate themselves and are threats to each other and threats to the people who work in the penitentiary. So if his privileges don't change, and the only thing that has changed is the designation, but he's still in a cell, he's still behind the walls, he's still under armed guard, what materially has changed for Paul Bernardo except he's in a program that can deal with high-profile sex offenders?
So let me disagree slightly with the premise of the question. That his conditions will not change, I'm not sure that's correct. I had occasion to observe that inmate in his conditions at Kingston Penitentiary a number of years ago. Very small cell. He was in there for 23 and a half hours a day. And then his yard, so to speak, had a tarp that covered that area so that he couldn't see the sky. That will not be his experience at La Casa. He will have, and I think this is on record, he will have greater interaction with other inmates. However you view that, it is for me a point of destabilization in that institution. And that factor is also not accounted for in the regs properly, and it could be. In other words, I wouldn't want to be the warden of La Casa because of the particular code that inmates in this country, at least, and in many, seem to apply. That's a dangerous thing for that institution and its order, and the whole system works on good order.
Okay, Andrew House, I always appreciate your perspective. Thanks so much for your time.
Thanks, David.